Thank you. And I'd ask maybe Takashi can give us the green light to go ahead and get started, because we have a lot to chat about today.
Yes, for sure. Thank you, Meg. Good morning, good evening, and good afternoon to all. We will resume the forum starting with session 2 this morning over here in Japan. Session 2 on the ICSID Rules Amendment will be moderated by the Secretary General of ICSID, Ms. Meg Kinnear. Meg is also Vice President of the World Bank Group, and as Secretary General of ICSID, she oversees a group of 70 staff members who work professionally to administer investment arbitrations. We are also honored to have 6 prominent professionals in the field of investment arbitration as panelists of the session. Meg, it's a great pleasure and honor to have you, and the stage is yours.
Thank you. It's a pleasure to be here, and good morning to all. We have an absolutely top-notch panel, so I'm really delighted about this opportunity to talk a bit more about the amendments. What I'd like to do just to start off is a quick, short refresher on ICSID. As you will probably know, ICSID was established in 1966, and its mandate was to facilitate dispute resolution between foreign investors and the host state in which they invested. So it's all about cross-border investment, improving investment climates, and encouraging investment in foreign countries. It gave recourse to arbitration and conciliation, and what was very novel about it was the idea of giving direct recourse to the investor who was making a claim. And it very definitely set up an impartial system with a number of provisions that would reinforce the idea of an impartial, autonomous, and depoliticized method of dispute resolution. Among the features to depoliticize was the fact that everything, all of the adjudication would be done within the ICSID system and not going out to the domestic courts. And what was particularly valuable was the enforcement mechanism. And essentially the enforcement mechanism at ICSID is a simplified mechanism where you don't have to take the award and have it both recognized and enforced as you might in a New York Convention situation, but rather you simply take the certified award from the ICSID tribunal or committee and you file it with a designated court by the state, and it has the same power as a final judgment of a court in the state. And that, I think, is probably considered the gold standard of ICSID. We have now grown from 20 original members to 156 member states. And in fact, Japan was one of the first signatories ratifying the convention in 1967. All of the cases are based on written consent between the parties. So it is not just the fact that the country that you are a national of is a member of ICSID. You need that additional piece, which is written consent to arbitration or conciliation under ICSID. And we see that written consent usually in a contract, a foreign investment law, or an international investment treaty. Today, about 75% of all cases are based on some form of international investment treaty. They may be bilateral. There are quite a number under the Multilateral Energy Charter Treaty, and there are some under other multilateral treaties. And this trend of a lot of treaty arbitration in particular was something that started in the late 1990s and really is responsible for the increase in investment arbitration that we've seen in the past several decades. And you can see from this slide, the blue peaks are basically the increases in foreign investment, and the yellow is the cumulative number of investment agreements. And what's interesting, and perhaps not surprising when you think about it, is as there has been an increase in the amount of foreign investment, obviously with ups and downs over time, there has also been an increase in the number of these treaties, and almost all of them provide dispute settlement, and almost all of them give ICSID as either the only or one of several options for rules that would govern the investor-state dispute settlement. So we know this trend is continuing today, and we also know that ICSID has done more than 75% of all known investor-state cases. So it really is considered the premier institution in this field. And we are very lucky to be staffed by a number of wonderful counsel who contribute to that. We have been providing a number of methods of dispute resolution, and interestingly, since 1966, we've had both conciliation and arbitration, but arbitration has been by far the dispute settlement method of choice for parties. And my sense is that is because usually by the time parties get to an investor state case, they have really exhausted their other options of trying to negotiate with government authorities or trying to resolve in some way. And when they get to the point of initiating an investor state case, they are frequently just looking for arbitration and a final binding award. Over time, we have had, of course, the conciliation and arbitration under the ICSID Convention, which is the main work that we are doing. But we have also, you will see in the middle silo, issued a set of rules in 1978 which permit conciliation, arbitration, and fact-finding, but in a case where only one of the disputing parties is a member of the ICSID Convention. So under the first option, both the investor and the host state must be members of ICSID. In the middle, only one of those two must be from an ICSID member state. And this is one of the big changes we'll talk about later in the new rules that are coming up. From the time of their passage on, in fact, neither party will have to be from an ICSID member state, so it will broaden access. And then on the third pillar, you will see there are a number of other services provided, including things like acting as an appointing authority. We have been starting into mediation, and that's something we'll talk about today. We've been a registry for other treaties, and we have also started doing investor state cases under the UNCITRAL rules, under other ad hoc situations, and even in some cases, we have done state-to-state cases. But our bread and butter to date has been the arbitration under the ICSID Convention. From time to time, as you would expect, we do update our dispute settlement rules like any institution. And in this case, most recently, by 2016, it became clear that there were a number of areas where we saw an opportunity to update. Some of these being little tweaks that we saw in everyday practice that came up in particular fact situations, others being ideas that were being talked about in the broader investor state community. And you will probably be quite familiar with the fact that there has been a lot of discussion about reform recently, and in particular about procedural reform. So there were a lot of these conversations ongoing, and we thought that perhaps this was an opportunity to have that conversation in the ICSID context as well. So we announced to our member states in late 2016 that we were going to embark on this project and started it in earnest in 2017. And our main objectives really were, first of all, to provide a greater variety of dispute settlement tools for parties, to update our rules, and in particular, to update our ADR type tools. And when I'm talking ADR here, I'm not just saying arbitration, but to really update conciliation and to start with a standalone mediation rule, and also to have fact-finding updated. So we wanted to do that. We also wanted to try to address concerns about the time the process took, and time basically equates to costs in the investor state process. So we wanted to address that, and I think that's a universal concern, not just in investor state, but in all arbitration. We also wanted to continue to increase the transparency of the process, which is something we had done to some extent in the 2006 rules and is a continuing theme in this area. So we began basically with a scoping process, asking anyone who was interested through a very public and very transparent process, first of all, what they thought should be addressed. And this perhaps became the most comprehensive ICSID rule amendments because we got a huge amount of uptake from states, from arbitrators, counsel, and from public interest groups, suggesting various topics that they thought should be discussed and potentially should be the subject of amendment. So from the beginning, we made this very much a transparent process and a comprehensive one. And you can see in those boxes, we essentially settled into a working method where we put together something we called a working paper, which essentially had the rules with proposals and draft language for amendment and an explanation of what the proposed amendment was intended to do. It would go out, we would receive public comment on that, and then we would have an in-person meeting with our states for a full week at ICSID. So we had this process ongoing and basically had 3 full in-person consultations. And by November 2019, we had got to working paper number 4 and a member consultation. And we were ready to, by February 2020, and we were ready to have a final consultation when, of course, the pandemic sent us all home. So at that point, we decided to have a little bit more written consultation. And ultimately, we got to November of 2021, where we published working paper number 6, which was the final working paper. And just to give you a visual, frankly, the first working paper looked much like an old-fashioned telephone book. It was huge. And every time we went to a new working paper, we were able to get consensus on certain items and hone down to the last issues that were in dispute. So when you look at working paper number 6, it is only about 25 pages, and it was the last, perhaps the most difficult rules to get consensus on. But the process, although long, was actually very effective in getting a lot of consensus among states, and from what I can tell, a lot of consensus in the bar that is going to be using these rules. So we are now at the stage where we have proposed to close consultations, and we will be going to a vote. And in fact, today, we advised our member states of the schedule for this. And so on January the 20th, we will be sending a letter to all member states with a voting ballot, which will look something like you see on this slide, and the 4 resolutions, which cover, first of all arbitration and conciliation under the convention, which requires 2/3 of the membership to approve it. Then the additional facility rules, including additional facility arbitration and conciliation, which is the 2nd resolution. The 3rd will be adoption of the ICSID mediation rules, and the 4th will be the adoption of brand new fact-finding rules. So that is what will be put in front of our membership on January the 20th. We are giving by the standards of past amendments, a relatively long time for members to cast their vote. We've asked for votes to be cast by the end of business on Monday, March 21st, but we felt this was important, and this was something that states had said to us, because it is such a big package, they wanted a good amount of time to be able to look through it and to cast their vote. So essentially, it's a 2-month period to cast their vote. And if approved, which we certainly hope and expect it will be, these new rules will enter into effect on July 1st of 2022, which is both our new fiscal year, but also gives us a little bit of time to change our case management system, to create templates, to do some training, and to do the kinds of things you need to implement the rules. So this leads us to our discussion of the amended rules. And what we would like to do now is turn to our panel. As I've said, we have just an incredible panel, and I know that you have their full biographies, but if I could just quickly introduce them, and they can wave or certainly you have their names there, but just to introduce them, we have Toby, and I will do this in alphabetical order. Toby Landau, who is a barrister at Duxton Hill Chambers and has been an arbitrator in various investor state and other public international rules. We have Professor Campbell McLaughlin, who is an international law professor in New Zealand, an investor state arbitrator, and also an author of a very good text that we certainly often consult. We have Yoshimi Ohara, who's a specialist in arbitration and mediation in Tokyo at Nagashima, Ono, and Tsurumatsu. And I should note that Yoshimi is also recently a member of the ICSID panel of arbitrators appointed by Japan. So we're very pleased to have her on the panel list. We also have Mei Tai, who is a specialist in international arbitration and managing partner of the Asia offices of the law firm Herbert Smith. And we have Eduardo Zuleta, who is an extremely experienced investor state arbitrator, has done a number of cases at ICSID and with other institutions, and is also a member of the World Bank Sanctions Board. So you have an extraordinarily qualified and experienced group. I believe we are also going to be joined by Jeffrey Commission, who is with Burford Capital and a former counsel at Freshfields. I don't see Jeffrey at this point, but I believe he will be joining us later in the session. And finally, I'd like to introduce my colleague, Geraldine Fisher. Some of you may have met Jerry already, but we're really pleased to say that Jerry is basically hosted in Japan for the next several years. And she provides, I think, a fantastic resource literally on the ground. And I would truly encourage you, if you have any questions or any queries or would like any kind of presentations about ICSID, please do get in touch with Jerry, because she's right there in your neighborhood now. So I think that's a wonderful thing. So the way we'd like to proceed at this point is that I'll give a short introduction to the relevant provision, and our panelists will give us some of their thoughts about the new rule, ideas, perhaps about how to implement, will it address the issues that it's seeking to address, and that kind of commentary. And we're hoping that through this, you'll be able to familiarize yourself with some of the new rules. And we've certainly tried to keep ourselves to the ones that were probably the last negotiated, or perhaps the most negotiated. So they are probably, as rules go, the most interesting ones. We'd like to start with the theme of this conference, which is investor state dispute settlement in the digital era. And one of the things that the new rules tried to do was to incorporate a lot more use of technology. And so, for example, it makes all filing electronic. It allows awards to be signed electronically with the consent of the parties. And it reaffirms that hearings may be done remotely, in other words, fully by computer. They may be hybrid, which is a combination of in-person and remote technology, or they may be done in person as the parties wish. We thought we were ahead of the curve when we started to propose these. And again, the pandemic sort of pushed us all into a new realm of being very technology savvy. So since March of 2020, we have actually been doing all filing electronically. We've done more than 380 remote sessions. And the nice thing about this is that this is all working very well. And we have not had any problems with the remote filing. And in terms of the remote hearings, I think we have all increased our familiarity and our ability with remote hearings. So they go very smoothly, and people have become very expert in the last 18 months. And I'd like to start just by asking our panel, who were forced into this brave new world with us, what your thoughts have been about moving to remote technology, in particular for hearings, and whether you think this has been successful and how you've navigated any kind of problems that might have arisen.
Perhaps I can start the ball rolling, Meg. Just to say that I guess my experience was that necessity is the mother of invention. I'd always been in favor of the use of video conferencing for procedural hearings, but the big step change that the pandemic drove us all into was having to conduct full witness actions remotely. And what that drove was both a huge technological advance. Fortunately, the technology was there, and the companies worked very fast to adapt it for use in arbitration hearings. But it also drove a huge development in practice of some significance, I think, in terms of the development of the standard hearing protocols to try to anticipate in advance all of the practical issues that might arise in order to conduct a virtual hearing. I guess my feeling is, looking back over the experience of the last 18 months, which after all has been so extraordinary for all of us, is that really the problem has not been with the technology. I feared it would be, and it was not. In fact, in many ways, the technology was curiously democratizing for witnesses, I think. The ability for witnesses to remain, because they had to remain at home, enabled them to often to give evidence in a perhaps less intimidating environment than might have been the case otherwise. It enabled us to carry on doing our business, often at rather hostile times, but then the world is round, what can we do? So if I ask myself what's the real disadvantage of the video conferencing hearing, I think it's really not in terms of the things that I was most concerned about, which was, would I be able to make a proper evaluation of the evidence? Curiously, it seemed to me that one could develop just as good an impression of a witness on the screen as in reality. Of course, it would be impossible to test that empirically, but one had the sense that one was getting the measure of the witness. And it is, after all, still a formal hearing. There's a transcript, the documents, and all the rest of it. And at the end of the day, that's what one goes back to when one is drafting an award. So what are the possible drawbacks? The first is, I think there's still some considerable reluctance on the part of parties, and I've noticed that particularly in the Asia-Pacific region, to agree to video conferencing as a means of conducting merits hearings. Not in all cases, but in some cases. Of course, if both parties, if neither party wants a video conference hearing and they're both prepared to wait, it's a bold tribunal that would then impose such a hearing on them. Arbitration is, after all, still a human enterprise, and people want their day in court or their day before an arbitral tribunal. And there is something indefinable about physical presence, bringing people together, which builds the trust and legitimacy in the process, which by reason of the pandemic, we've had to forego. I think the other disadvantage perhaps of the system is simply that all those opportunities for informal exchange, particularly between tribunal members, short of a formal deliberation, tend to be lacking. And that's very often where one builds the kind of consensus between tribunal members that one would wish to achieve. So reflecting on it from my perspective, I would say, I think it's been remarkable and a remarkable success in an otherwise bleak period for the world. But I salute those who've made it available to us. I equally hope very much that we'll be able to return to in-person hearings with that deeper contextual nature of an in-person hearing that the best technology in the world can't completely replace.
Interesting. Do others have the same reaction with their experience with the remote hearings?
If I may, this is Yoshimiharu speaking. May I just interject my views? Because Professor just referred to somewhat reluctancy in Asian region towards virtual hearing, I would say we have very good positive experience with respect to virtual hearings in terms of international arbitration. In terms of domestic arbitration, we sometimes still use live hearing, we conduct live hearing, but in terms of international arbitration, unfortunately, we didn't have luxury of having in-person hearing, which I missed very much. The virtual hearing has been successful, I would say, particularly when there is a trust between parties and party counsel, and tribunal members communicate each other quite well. As Professor mentioned that, you know, in the remote hearing, it is more difficult to resort pressure to witnesses. So I would say if there is a critical cross-examination involved in the proceeding, I would rather prefer to have in-person hearing, even under this very useful technology available to us. And talking about deliberation among the tribunal members, I do echo the comments just made by Professor, but some tribunals seems to communicate very well, even when the hearings are conducted virtually or case management conferences are conducted virtually. But some tribunal members do seem to have less communication among the tribunal members. When a virtual hearing is conducted, tribunal members are easily disrupted during the hearing or during the day, and it may be harder to get commitment from the other tribunal members. So we hope that this problem will be resolved by particularly presiding arbitrator taking strong initiative to have more frequent communications among the tribunal members. Thank you.
Exactly.
If I may add, I generally agree with the comments, but I would say that there are virtual sessions and there are virtual sessions. There are situations in which the parties would accept a remote hearing with no hesitation whatsoever. For example, annulment cases. In the vast majority of annulment cases, the parties have no problem whatsoever in a virtual hearing. Procedural sessions where you don't have witnesses, jurisdictional sessions, for example, where you don't have witnesses of experts. And I've seen a lot of reluctance, of course, when you have either expert witnesses, particularly in complex cases involving oil and gas matters, construction matters. There, the parties are very reluctant and they want their day in court, at least for the part of the hearing that involves the experts and the witnesses. The other cases in which, of course, I've seen a lot of reluctance is when there is a huge time difference and you have to start, one of the parties starting at 6 a.m. and the other is midnight. But generally, I would say that the experience has been good and that in the future, we will have a number of sessions that will be virtual. And we will not do sessions that we were used to do in person. The first session, for example, is something that would. And finally, in connection with the deliberations, I've noticed a substantial difference. When you know your co-arbitrators, when the three members of the tribunal know each other from other cases because they have worked together, the deliberation is quite easy virtually. When you don't have that experience, and you are not able to create the personal bonding that you create during the hearings in presence, the deliberation may be much more difficult.
Those are excellent observations, and it probably tells us the direction we're going to end up going in with hybrid hearings, and those with witnesses will probably be more likely to be done in person. So I think
I would, Meg, I wonder whether I can just interject some other points very, very briefly, just to perhaps put a more positive side on this. I think there has been a lot of reluctance. There was a lot of reluctance originally at moving our world into a remote one. It was something that we were forced into. And I think you can't really perhaps think of a more conservative profession than the legal profession in changing its ways. But I think in addition to the comments that have already been made, my sense is that the experience over the last 18 months, in cases of all shapes and sizes that have been done remotely and very successfully, is actually that there's a very positive impact on the process itself, because we've had to retool and reconceptualize to an extent the way that we conduct arbitration in order to make it work online. What has not worked has to simply transpose what we used to do physically into a remote environment. We've actually had to change things, and those changes, I think, may have lasting effects even after the pandemic. In particular, we no longer jump on and off aeroplanes because we can't. We used to do that far too much. It was environmentally unsustainable, and it was expensive, and it caused a lot of delay. Now, at a flip of a switch, we can have a hearing. And that actually means that we can have more hearings than we used to have. and separate hearings, rather than building up to only one, for example, major hearing and limiting any procedural contact beforehand. One can deal with issues very easily now by simply arranging a Zoom meeting or whatever other platform. I think that has an impact on the structure of arbitration. It will increase contact along the way between parties and tribunals. I also think there's been a major increase in accessibility for hearings. In the old days, not everybody could jump on a plane and actually go to a hearing and participate. Having a remote hearing now means that actually anybody can click on and access the hearing from anywhere in the world. That's not just members of the public when members of the public have access. It's also members of teams, including governmental teams, I've noticed. Whereas in physical hearings, governments may have limits on the amount of people they can physically or financially support sending abroad. Nowadays, in this environment, you can have large teams just clicking and logging on to a hearing and participating from home or from their home office. It has a big impact on, I think, the legitimacy, the accessibility, the understanding of the process in having more people actually involved. And I also think that we have learned to be more focused in the way that cases are presented and the focus, the areas of interest that tribunals will set out themselves, because time is more precious online, because it's harder to be online for longer periods of time. So I think the parameters of a video hearing will actually have a wider impact. And I have to say, I think the increased use of technology in the new draft rules is extremely welcome with all of that in mind.
Tremendous, thank you. The time and cost issue is actually a good one. The new rules have tried to address time and cost, and frankly, we studied where delays happen, and there's no one area, and every case has its different delays. And so we decided that we would try to do multiple things in the rules that hopefully cumulatively brought down the overall time. But one of the things in particular that we did was we put a lot more actual time limits. So for example, most motions have to be decided in 30 or 60 days. We put in particular a rule that required all of the parties, arbitrators and the disputing parties, to conduct a proceeding in an expeditious and cost-effective manner. And you'll see that wording throughout, so that it's meant to be a factor throughout. And we in particular put some timelines on awards, so that awards on jurisdiction should be issued within 180 days after the last submissions. That's usually going to be your oral submissions before the tribunal. And awards, which are a combination of merits and jurisdiction, should be done within 240 days after the last submission. So we put some deadlines on those kinds of awards, so that we hope that they will be issued respecting that. And that's one of the bottlenecks that we found in several cases. I wanted to ask members of the panel if they think that these deadlines, first of all, will they be met, perhaps with difficulty in some cases, but what could parties do to make sure these deadlines are met? And what can tribunals do to make sure that these are not just aspirational, but they really are implemented? So certainly, again, anybody's views are most welcome on this issue.
Why don't I start off, Meg? It's May here. I think deadlines are good. As a lawyer, you're just used to having them: internal deadlines, client deadlines, external deadlines. So we're very used to it. And you know, I think more guidance and structure, the better. In commercial arbitration, we're now increasingly used to doing expedited proceedings where, you know, the whole arbitration has to start and finish in a 6-month or something like that, very, very short time frame. And so it won't be a surprise for us who are moving from commercial to investor state arbitration to be subject to the same strict time frames. And to everyone's surprise, who's used to taking a couple of years to complete an arbitration, it can actually be done in 6 months to a high standard. Where I guess I find that there are still challenges, notwithstanding the institutes having excellent guidance and timeframes and deadlines for the parties to abide by, is that it happens not infrequently that both sides, both sets of lawyers or both sets of clients want to go slow. You know, there are lots of reasons why a tight deadline is difficult to comply with, whether for personal reasons or cost reasons, or your witness is not available, or your client can't sign off. And in such circumstances where you have the parties agreeing that the deadline should be pushed out, it's quite difficult, notwithstanding the institutional rules and the tribunal's toughness on this issue, for the tribunal to say no, given that the philosophy of party autonomy and consensus is very strong in arbitration. So that's my experience, but notwithstanding that, I think the fact that institutions are being stricter is very helpful.
It's excellent. And, you know, there was that whole discussion about the systemic good of going quickly versus respecting one of the features of arbitration, which is if both parties consent to a different kind of timetable, that should be respected foremost. And that certainly came up in a number of discussions. Does anybody else have a thought about the shorter timeframes? And in particular, I think the awards is the one that a lot of people have focused on.
I can comment, and Yoshimi knows that very well as well, from the experience in the ICC, where deadlines were put, and there was a lot of screaming saying, well, you cannot put this sort of deadlines, you cannot force the tribunal to do this and that, that's going to affect the quality of the awards. And at the end, the result was very good, because number one, arbitrators were forced to be more efficient, and more efficient themselves to force, to some extent, the parties to be efficient. Give guidelines for the parties to the sort of submissions that the tribunal would like, give guidance to the parties as to the sort of issues. The key issues that the tribunal consider are the most relevant issues, and avoid a situation where you receive thousands of pages of things that may be irrelevant. So the end result was a good result. And the other side is the other thing that is important is that for the user, the fact of having a clear deadline for the tribunal to issue a decision gives some comfort, in the sense that the party can ask the tribunal, well, you have this term, what's going on? And not what happens when you don't have a fixed term, which is the tribunal simply saying, well, we're doing what we can, this is where we are. So I think it's a very good idea, and it has, as I said, it has worked in other institutions, and it has worked well. So I think it's a very good idea, and there's a lot that the arbitrators and the parties can do to meet the deadlines.
Tremendous, thank you. It leads into one of the other tools that have been put into the rules to try and help move things along, and Eduardo, you've sort of brought us to that, which is the whole question of case management conferences. We have seen a lot of successful use of this in the commercial setting and in domestic civil litigation. And one of the new rules is this Rule 31, and it's meant to really encourage parties and arbitrators to have case management conferences, and hopefully, if useful, frequent case management conferences throughout. And the idea here was not just to have procedural case management per se, but to do things like identify uncontested facts, to try and clarify what are the issues that are truly in dispute and that are going to be outcome determinative, and then to address any kind of procedural or substantive issue. So it is a broader remit, I think, as a case management conference rule than sometimes you see. And that was on purpose, to try and sort of empower arbitrators to really deal with little chunks of the case along the way and try and narrow down to what finally really mattered. And so I wanted to get your thoughts on case management conferences. I'm sure you've done this in some respects in the ICSID context, but mainly procedural, but in a number of other contexts. And there are a lot of questions about how do you make this device useful? When is the best time to hold the case management conference? What kind of techniques do you use to really make this one of the tools that makes the process much more focused. I think Toby and Campbell, you both had some thoughts on this, and I'd be delighted for any other thoughts from other panelists as well.
George, shall I'll kick off? I regard this Rule 31 as incredibly important. It is, I think, one of the more significant changes, positive developments in the new rules. Case management is something which we know well in many different types of dispute resolution, and it has become a very, very important tool in actually underlying the success, really, of dispute resolution in many different forms. Courts, commercial courts in particular, have shifted over the years into very active case management. We see that in many common law systems, noticeably, for example, in the new Singapore International Commercial Court. Case management has become a major step in the proceedings, where there is an obligation that lead counsel attend each case management conference, and there's a lot of preparation that goes into each meeting in order to structure the ongoing framework of the process. I think where to understand case management, one has to understand what is the problem if you don't case manage. The risk is, especially in our current system of arbitration, that tribunals will only meet the parties at the first session in the ICSID context, which would be within the first 60 days. They set out a procedural order number 1, which tends to be in standard form. And the risk is that everybody goes on to autopilot. That means whatever the needs of the particular case, they set out a standard form procedural order, which is for every kind of case, whatever its shape or size or characteristics. And then the tribunal lets the parties go off and prepare the case. They sit back as independent umpires, and the parties fight out the process in front of them. And they meet again at the main hearing. And in the meantime, they may have done many, many things, spent a lot of time and costs on actually matters that are not going to be significant in the end. So the process doesn't get properly tailored to the actual needs of the dispute. In order to make the process more efficient, that's in terms of time and cost, is particularly, one needs to keep an ongoing monitor in an ongoing way the actual nature of the dispute. What are its characteristics? What are the relevant points? What points won't matter? What areas might be uncontroversial or agreed? And one can do that only by active, ongoing case management. And that shifts the traditional adversarial model into something which is a little bit more inquisitorial, where the tribunal has actually got to roll up its sleeves and it's got to take the initiative itself in order to work out what really will be needed in terms of procedure in order to get to a resolution as quickly, efficiently, and fairly as possible. So Rule 31 now mandates at least one case management conference after the first session and is encouraging more than one. And I think with the modern best practice, that means frequent case management meetings, frequent opportunities for the tribunal to actually force the parties to reconsider the ongoing procedure and make sure that it is bespoke, cut out any redundancy, make sure there's not too much procedure, only what is important. And in the end, that means that the tribunal will be adjusting procedural order number 1 throughout the life of the arbitration. They may well cut out many standard parts of the process. They may add process if it's needed. I think that there are, in fact, we've seen in arbitration generally, a number of different techniques to make this work, including particular styles of briefing the tribunal after the first session. One example is something which is called the Kaplan opening, after Neil Kaplan, a well-known arbitrator in this field, which involves counsel meeting with the tribunal and actually opening the case with submissions way in advance of producing further evidence and further memorials in order to make clear to the tribunal, allow the tribunal to identify what issues are really in dispute and what are not, and what actually will matter, what will be needed going forward. So to me, this is very, very positive. It's very important. but it does actually place a very significant burden on the tribunal to get to grips and understand the case actively as it's going along, not just at the eve of a full substantial hearing.
That's very helpful. And one of the questions, I guess, is, do we think parties will welcome this because it will have a good impact overall, or will parties feel their presentation is perhaps too constrained? I don't know if others have views, or Campbell, I think you had some thoughts as well on case management conferences.
Thanks, Meg. Yes, and while I have the floor, I must do what I had intended to do first off, but it actually fits nicely here too, which is in the person and presence of Mr. Takashima, to commend the Ministry of Justice in Japan for partnering with ICSID and UNCITRAL in organizing this conference. My only regret is that I didn't get to visit Tokyo, but again, which is I very much enjoy doing. But for this very particular reason, which is that what we're actually doing here, if we just reflect on it for a moment, is putting together two very important elements in the international dispute settlement process. One is the engagement between states and the institution, reflected in this very wide-ranging review of the ICSID rules. And the other are the reflections from practice of arbitrators and counsel in how the existing system works. And that's rather important, isn't it? Because at the moment, in the Asia-Pacific region as a whole, I would say every possible manner of resolving investment disputes is currently under discussion across the spectrum, from arbitration, investor-state arbitration, through state-to-state arbitration, domestic court resolution, or the EU's proposal for a standing tribunal. But of course, the system that we actually have, which is currently operational, which we all have experience of, is arbitration. So that's why this is valuable. And I share Toby's view about the potential value of case management conferences, which I have to say I've always believed in and tended to try to insert in the ICSID procedure, even without, but with the parties' agreement, even without a specific rule mandate. And why am I so keen on them? Well, if you consider the normal course of an ICSID case, what tends to happen through two rounds of written pleadings is that each side becomes more and more committed to their own case theory and less interested in confronting the case theory of their opponent. Now, of course, that shouldn't be the case. The idea of defenses and replies and rejoinders is that one is successively joining issue. But in my experience, it is often the case that each party comes to the hearing very much with their own view of the world. And of course, they're entitled to do that. They must be entitled to present their case or defense, as the case may be, in the way that they think fit. But on the other hand, the tribunal actually has to decide between these two alternative views of the world. And very often, as Toby rightly says, we're trying to decide that against a truly vast arbitration record, much larger often than would be the record in many large commercial cases in well-known commercial court systems, because no real control has been imposed on the process or has been worked out on the process as it has developed. So I agree. I think case management conferences, which I have frequently used for procedural matters, are also very useful to try to hone the issues. There has, I think, historically been something of a reluctance on the part of arbitrators on the basis that it was feared or thought that this might in some way suggest that the tribunal was prejudging the substantive issues. But of course, that's not the case. The tribunal is simply encouraging the parties to identify and hone their presentation of the substantive issues for ultimate decision. And that does require some key choices. And I think it's a mistake to think of case management as being purely a matter of the tribunal's diktat, as it were. In fact, if a case management system works well, it should be a means of really encouraging the parties themselves to jointly take control of the process. And if that's going to happen, you need, in advance of the case management conference itself, to have the parties do quite a bit of spade work. You need to set it up effectively, in particular through such mechanisms as joint statements of issues, which give the tribunal, as it were, the parties' presented roadmap against which it can work to really tackle them on what is actually needed for trial. Because the other problem with the ships passing in the night approach to arbitration is that very often by the time a case gets to the hearing itself, there are simply too many issues on the tribunal's table and too much evidence for anybody to reasonably expect to do justice to in the course of what are normally rather short hearings. And it is very important in the interest of the parties themselves, and not only in the interest of the tribunal, to make sure that that time is spent wisely and well. So I think the first and most obvious time in which case management should start, if there haven't already been procedural issues which require consideration, is following that first round of written pleadings. Because at that point, you do know, in broad terms, you've given each side the opportunity to state rather fully what they say their case is about and the evidence that's in support. And of course, in the current procedure, that precedes their respective applications for production of documents, which has become often a rather broad and overly cumbersome exercise, in which itself needs to be focused based on the issues. So I very much favour having a case management conference at least at that point. There's an additional intangible benefit, which Toby did touch on in his earlier remarks, with which I agreed, where we can really take the benefit of the virtual technology, which is that the tribunal gets the opportunity to meet parties and counsel, and perhaps even more importantly, the parties and the counsel get to meet the tribunal and get a sense of them at a much earlier stage in the proceedings than would otherwise be the case. You know, the initial first procedural meeting is often a rather formal affair, but by the time there's been an initial exchange of pleadings, there really is an opportunity for the parties to be speaking to the tribunal about what's really going to be involved in shaping this case in a way that will enable it to be effectively determined. Thank you.
Thank you. Does anybody else have a thought on case management? Or what we can do now is proceed to one of the other tools that we hoped would address time and cost, and that was a set of optional expedited arbitration rules. And essentially, these are rules 75 to 86, but what they essentially do is, first of all, encourage a sole arbitrator. It's not required, but it's encouraged, and then it has reduced timeframes for each step in the process. And basically, it is a situation where you don't go off and have corollary motions on one issue or another, but everything is dealt with in a streamlined fashion. And if they were followed to the letter, the timeline would be reduced by about 50%. So they are useful, but I think a lot of people felt in the complex investor state situation, there are many situations in particular where you have issues of treaty interpretation where they won't necessarily be something that parties feel is very helpful. So these were decided to be opt-in and potentially opt-out. But we do hope that there are some particular circumstances where they may well be quite useful. One situation might be in a contract case. Another one where we're hoping that parties will at least consider expedited proceedings and perhaps even put in their treaties or contracts that where there's a small or medium-sized enterprise that they would at least consider doing an expedited arbitration. So those are the expedited rules that are in this new proposed amendment. And I'm certain probably all of you have had experience, at least in the commercial context, with expedited arbitration rules. And I wanted to know what you thought of the benefits of these and some of the lessons learned perhaps about how you get the best of expedited arbitration and where it might be useful or where it might not be the answer to the time and cost dilemma. And I wonder if anybody has views on that. We'd be happy to hear those thoughts.
I'll step in if nobody else is volunteering. There's now quite significant experience, I think, with expedited proceedings in commercial arbitration. It has been very, very successful. I think that there are perception issues with it, which may be more pronounced in the investor-state field. It is sometimes difficult to agree to expedited arbitration in advance. That is when you conclude your arbitration agreement. And that, of course, will be a significant issue in terms of drafting treaties, whether this actually finds its way into a treaty provision, or more realistically, whether parties will agree to it at some stage after a treaty, when there are a particular investor has actually been identified. If you agree to it early on, you're risking not knowing everything about the nature of the dispute. And some disputes might look simple and easily susceptible of quick, expeditious resolution, when in fact they turn out to be more complicated. So it can be quite risky to agree to expedited arbitration unless you really know the shape and extent of the dispute. But contrary to that, once you do know the shape of the dispute, then each party may have different views as to their best strategy. One party might think that expedition is sensible. Another party might think it's not going to serve its interests. And an added concern in this particular field is whether states will agree to expedition, because very often it is the state party rather than the investor party that requires the comfort of ample time in order to complete internal processes, internal consultations, and to allow the machinery of state to operate. Very often, not always, but very often is much slower than that of the investor. So I think the jury is out really as to the extent to which this will be adopted in the investor-state field. But one thing I would say is that the actual proposed expedition in the new rules, the draft rules, is much more generous than actually most commercial arbitration expedited rules. In talking about expedition in the investor-state context, the new draft rules are still allowing quite a lot of time to each side and quite a lot of procedure. So the first session is within 30 days rather than 60 days. The procedural schedule thereafter still allows periods of 60 days and 40 days for drafting memorials, and page limits of 200 pages for a memorial, 100 pages for a response, and then a hearing 60 days after. That is still slower, actually, than many expedited systems in commercial arbitration, understandably so. But I think from that, one should be able to take comfort that agreeing to expedition under the new rules actually will be sensible in many cases and shouldn't be putting undue pressure on any parties. But we will have to wait and see to what extent people's perceptions catch up with that. Thank you.
Exactly. That's very, very useful. We thought we would move on to arbitrator challenge. And this is a topic that is discussed quite a bit in investment arbitration. The new rules have done several things in the arbitrator challenge spectrum. The first is to put some definite timeframes and shorter timeframes. So a proposal to disqualify would have to be filed within 21 days of learning the relevant facts that are the basis of your disqualification. There is then a fairly expedited schedule for the parties to brief on the proposal for disqualification, and it would add up to about 28 days in total. And then the decision on the disqualification should be issued within 30 days of that final briefing. So it's meant to be a relatively quick process. The other change here is that in the past, and according to the current rules, there is an automatic suspension of the proceeding when a disqualification proposal is filed. And that can sometimes be disruptive, especially if the proposal is filed, for example, a week before the hearing is scheduled or that kind of issue. And we're hopeful that the combination, first of all, of the definite timeline for filing the motion will be helpful to prevent that kind of situation. But as well, the parties have been given the option not to suspend the proceeding. In other words, to be briefing on the disqualification proposal, but that the schedule otherwise continues. And that perhaps you can see as being relatively simple if it's simply doing submissions that are due in 2-3 months. Why should they have to be suspended for the disqualification? But you can see that perhaps parties would want this suspended, especially if there is a challenge to one of the arbitrators who will be hearing the matter. So that is an option of the parties, but was not made mandatory. And finally, we have the situation where if the arbitrators who are not challenged are unable to decide the challenge for any reason, they may refer it to the Secretary General and the Chairman of the ICSID Administrative Council, so that it tries to very quickly say, if the arbitrators are unable to decide this matter for any reason, they can quickly move it to the ICSID mechanism for a decision. So the rules in Article 22, which you see here, and 23, hopefully will address questions of delay, and hopefully will address concerns that we hear, whether they're justified or not, about what people call a strategic challenge, one that's meant to slow down the process. And one of the corollary rules that may also help in this challenge context is the rule on costs. And perhaps that can be used as well to curtail strategic challenges. So I wanted to see what your reaction is to the changes on the challenge procedure. And I think, Eduardo, you were going to start us off with some thoughts on this rule.
Okay, thank you, Meg. I think it's a very good change, a necessary change on several grounds. Number one, because Rule 9, which is the existing rule now, has vague terms that have been interpreted in a different fashion. It says that the proposal for disqualification shall be filed promptly. If you look at the decisions as to how promptly has been defined, it means anything. Tribunals have resorted to the definition of promptly in the English dictionary from the comparison of the different languages of the treaties, basic drawn on experience from other tribunals, but not all the decisions are available in public. Even a resort to the rules of other institutions, the rules of UNCITRAL or ICC, to try to define what is promptly. And promptly can mean 10 days, 15 days. So there's nothing clear there. That's the first issue that I think these modifications clearly address, because now you have defined time limits, a short term for the party to file the request for disqualification, a clear term as to how the term is counted and from which date it is counted. Is that it has a fixed term for the arbitrator who is being questioned to reply, which again, under the present Rule 9, arbitrators were extremely flexible in giving the colleague the necessary time for him or her to reply. It takes care of another difficult problem, which is when the co-arbitrators really do not want to take a decision on the questioning of the colleague. And it happens quite often, and for several reasons. You see a number of articles and even books saying that the reason for arbitrators not wanting to decide on the challenge is because this is a sort of a small club club of that's not, I don't think that's the real reason. There are a number of situations, and I can give you some practical examples. Two relatively new arbitrators who have to decide on a challenge of a senior, very well-known arbitrator, and they don't want to take the decision. So this gives them an option not to simulate that they have a difference, but to say we don't want to decide, period, and then it is for the chair to decide. Another situation that I've seen is a case where an arbitrator has been challenged before by the same counsel in a very aggressive fashion, and the arbitrator does not want to get involved in the decision. So this again gives the panel of the two arbitrators an option to say, we don't want to decide. We don't have to give any explanation, simply we will not decide. And probably the practical effect of this would be that we will be seeing more and more decisions from ICSID, from the chair, and that would allow the building of a more predictable set of precedent, which is what we have in other institutions like ICC, for example, where you have the institution has a certain set of precedents that the parties refer to. So I think in general, this is a very good change, and it will reduce definitely the time. The other point that I wanted to make, of course, is the situation under the present rule. It simply says that the procedure shall be suspended, period. Here, you give the parties the option not to suspend the proceedings. And there are a number of practical situations where it's better for the parties and the panel and everybody not to suspend the proceedings. Let's give, for example, a case where you are 3 days away from the procedural hearing, and then a challenge takes place. Why would you suspend the procedural hearing because of the challenge? I don't see any. Or the proceeding is in a situation where, I don't know, claimant has to make the first submission, and the first submission is 5 months away, and there's a challenge comes. Why would you suspend the proceedings? Because suspension, non-suspending the proceeding would basically have no impact. So there are a number of situations in practice where this rule would allow the parties to keep the proceeding going, to handle the proceeding in an efficient manner, and not having to suspend as it happens now. So I think this was a very important and a dramatically necessary change in the rules.
Thank you. I think that's very interesting. Does anyone else have any thoughts on challenge of arbitrators? Good. All right. Well, what we wanted to move on to now was the whole question of third-party funding. And unfortunately, I think Mr. Commission hasn't been able to join us. So allow me, if you will, to at least tell you a little bit about this third-party funding rule. And this, I think, is fairly one of the most controversial topics in investor-state arbitration. I think if we go to the next slide, we'll put the new rule for you to read. It's Rule 14, and it is a completely new rule. And essentially, the rule requires the parties to disclose the name and address of any non-party from whom they receive funding, so the name and address of the funder. And it needs to be a funder who they receive funding from directly or indirectly, and to also disclose the names of the persons and entities that own and control a funder. And you can see that obviously the concern, and it was one raised in particular, I think, by a number of states, was a concern that someone might be providing funding and that there was some kind of entity behind that funder who had some kind of motivation to provide funding for the case and to see the case go forward. The name of the funder has to be provided to the potential arbitrators, and the main point of this rule is to avoid any inadvertent conflict of interest. Now, this rule is applicable to both claimants and respondents, although we know currently that most third-party funding is obtained by claimants, but there are investor state cases where respondents have had third-party funding. So it's a rule that applies to all disputing parties, and they have to keep the third-party funding disclosure up to date throughout the case. One thing that was certainly a discussion was whether the party being funded had to actually provide the funding agreement. And there were a lot of people who brought up the point that this really was unnecessary to avoid the conflict of interest concern, and also that in the funding agreement, you might learn confidential business information, you might learn something about the strategy or assessment of the case, and there might be disclosure of things that were not necessary for the purposes of the rule and could be prejudicial to the party being funded. So it really is a disclosure of the name and address of the funder and any party behind them who is providing funding. If a party believes that they need further information, they are able to ask the tribunal for that information. But in that case, the tribunal will apply the usual case for requiring disclosure of information, which is whether it is necessary and relevant in the circumstances of the case. So we will see how this develops, but it is a brand new rule. It is one that I think is necessary in the investor state context and is one that's been talked about as well in the commercial arbitration context. So that's a little bit about our third-party funding rule. I know Jeffrey was going to provide some statistics and a little bit more in-depth information about funding, but perhaps that'll be the topic of another day. But I'd certainly love to give our panel and anyone on the panel an opportunity to speak to third-party funding if they have any views on the issue of funding, but more generally on this rule and how it has been crafted. I can certainly say we spent a lot of time discussing the whole issue, and it is one that evokes a lot of strong feelings among those in the investor state community.
I can just chip in very briefly, Meg, just to say that this is an issue that's also been very, very live in commercial arbitration, and the experience there, I think, has been a positive one in the sense that there's now a realization, whether you like it or not, that third-party funding is a reality. It is increasingly widespread. It has very important purposes, not just for impecunious parties, but many other parties who now use it as part of an active strategy in terms of their litigation activity. And because it's so widespread, one has to deal with disclosure issues in the same way as you need to know the nature, obviously, the identity of the parties and the representatives before you as a tribunal. If you've got a third-party funder who actually is in some sense a proxy or in some sense a real principal, then you need to know their identity also to clear conflicts. And because there has been reluctance to do that, the rules that have now been implemented in commercial arbitration for disclosure have been very successful. I think this new Rule 14 will be very, very necessary, and I think will just what would otherwise be a contentious issue. Thank you.
Perhaps I can just add also, Meg, that once again here, at least in the investor state context, ICSID is leading the way, and I think disclosure, a requirement of disclosure in terms of clearing conflicts is important for both parties and not just for the tribunal. After all, why do we have a system of conflict, determination of conflicts? It's in order to ensure that the parties have before them an impartial tribunal. And if in fact there is some undisclosed connection which the tribunal itself can't be aware of between a funder and a tribunal member, that would have imperiled that impartiality. It was for that reason that the Institute of International Law in its 2019 resolution on the equality of the parties also endorsed a principle of disclosure of third-party funders as essential for the maintenance of the impartiality of the tribunal. So I think this is definitely a step forward in circumstances in which third-party funding seems to have become so widespread. Thank you.
Absolutely. Thank you. This leads well into the discussion of the next rule that was significantly adjusted, and this is the rule on security for costs. In current practice, security for costs is dealt with as a provisional measure, and so you have that very high standard of absolutely necessary to issue it. And increasingly, parties were bringing applications for security for costs, and it was thought that because it is a little bit different than a lot of the other types of provisional measures you see, and because it's something that you see fairly often, it was worth having a standalone rule addressing security for costs. So the result is this Rule 53 that you have in front of you. And again, you'll see there is a specific procedure which puts a specific 30-day time frame for a decision on the security for costs. But perhaps what's most interesting or most novel is that in the rule, it suggests relevant circumstances that the tribunal ought to consider when it's determining whether to issue security for costs awards. The first one you would expect, I think the first and second are quite obvious, which is a party's ability to comply with an adverse decision on costs, but secondly, their willingness to comply with an adverse decision on costs. The third one, I think, is an interesting one, but an important one to bring balance to security for costs, and that is what would be the impact of ordering security for costs on the other party's ability to pursue its claim or counterclaim. I think we often forget that sometimes it is difficult to fund security for costs orders, escrow funds or guarantees or whatever it may be. And sometimes it takes a little bit of time to get that in place. So the rule requires both sides of the equation to be considered. And then lastly, the conduct of the parties in terms of security for costs. And this could go to a number of things, but in particular, if there is a concern, for example, that the security for costs application is simply being used as a strategic tool and is not really out of a genuine concern about the adverse decision on costs being respected. So we will see how this gets interpreted as the rule is applied in practice. One thing that did come up in particular when we discussed security for costs was whether there was any relationship between the existence of third-party funding and security for costs. So the question was, if you have third-party funding, does that automatically mean you are impecunious? And if so, that there almost automatically should be security for costs ordered. And that was something that we felt was not justified on the what we know about when third-party funding may be obtained. And so we wanted to make that very, very clear. So the rule sub 4 basically says that obviously a party can plead evidence, including about third-party funding, but the mere fact of third-party funding does not determine whether or not there should be a security for costs order issued. So I wanted to ask, and I think perhaps May, if you could lead us off on this, do you think that this rule is going to change current practice on security for costs, or does it really basically include the usual considerations tribunals have? And if you are a counsel for a party requesting security for costs, what kind of evidence do you think the party ought to pull together to support their request for that kind of an order?
Thanks, Meg. I think that those are really good questions. Just as a sort of preliminary point, I wanted to mention for those of us that are not practicing in common law jurisdictions, just a little bit about the basics first. Just that security for costs is an order that is commonly seen in common law court proceedings, where there is the sort of concept of cost shifting, meaning that the losing party pays the winning party's costs. And the rules of court in these common law jurisdictions provide for it. But in many cases, and I speak from the position of dealing a lot with arbitral tribunals and parties from China, for example, there is no express power to grant security for costs because the cost shifting rule is not prevalent. And so this is probably something that's quite new to some of us in many ways. That said, in the ICSID context, as you mentioned, Meg, even in the existing rules, which doesn't have an express provision for security for costs, there is quite a strong practice now. I think I read somewhere that about 20% of all provisional measures applications made are seeking for security for costs. And I think your question was whether the new rules are going to basically codify the existing practice, or whether it will set a new standard, and so the existing case law on this issue will no longer be so relevant. Of course, only a handful of tribunals applying the existing provisional measures regime have actually gone on to order security for costs. Notwithstanding, as I mentioned earlier, about 20% of these applications are for security for costs. And that is because, and I think you alluded to it, that the existing standard is very high. It requires necessity, urgency, exceptional circumstances. And so very rarely did the respondent succeed in seeking security. Now, it remains to be seen how the tribunals applying the new Rule 53 will actually apply them. But I think there is an argument to be made that the standard is arguably lower because there is the absence of wording such as exceptional circumstances. And this is likely to mean, I suppose, first, that we will see an even higher uptick of ICSID security for costs applications. And secondly, it's very likely that the subsequent decisions applying Rule 53 and all the factors and criteria that is needed under there will then supersede the earlier decisions, many of which were unsuccessful. In terms of the circumstances that the tribunal needs to take into account, it's very clear that the Rule 53 is intended to give the tribunal a lot of discretion about this issue. However, with some guidelines, the ability to comply, willingness to comply, fairness of the order, the conduct of the parties, and controversially, as you mentioned earlier, third-party funding. Now, these are give a lot of scope actually for different types of submissions and evidence from the parties. I hope that parties won't go overboard, because at the end of the day, this is just an interim relief. It's not the sort of entire war between the two sides, the entire proceedings, and hopefully there will be some reasonableness applied to the evidence and the submissions that will be made. However, as I think you mentioned earlier, it is a very, very important procedural step, because an order that is made but not complied with could lead to the end of the case if the investor is unwilling or unable to pay. But hopefully that will not happen too frequently, because again, as I read somewhere, I understand that in very, very few cases are costs awards unpaid in practice. On the third-party funding point, I wish that Jeffrey Commission was here to share his insights. Unfortunately, we don't have him, but if he were here, I'm very confident that he will say that historically, states have sought security where third-party funders were present, because that they assume that this meant that the investor is not good for the money on its own, and they then have concerns about that, and also concerns that funding is not good comfort if the funding agreement does not extend to covering cost orders made against the investor. However, I think there's been a lot of recent research, including statistics that Burford has published, showing that many in-house lawyers and businesses are increasingly using third-party funding as a commercial allocation of risk and of assets that frees up investment capital to be done by other things within the business. And it is no indication of an investor's ability to honor its commitments to pay cost awards ultimately if it were to lose the arbitration. So I hope I'm doing Jeffrey justice by summarizing it in that way, but I think that's the point that the third-party funders would want to make.
Absolutely, and I think that's very, very useful. Does anyone else have any thoughts on the security for cost provision in the new rules? Good. Let me just move on then to a related provision, which is costs. And after that, I wanted to go back, and I apologize, I did skip one very important rule, which is manifest lack of legal merit. But since we've talked about security for costs, let's just move to the other related rule and the changes on the criteria for awarding costs by the tribunal. And as you probably know, at ICSID, at the end of the day, there is an award issued, and it needs to tie up all of the questions in the case, including costs. And costs have always been and remain under the convention totally within the discretion of the tribunal. But we have seen over time that a number of criteria are often considered by tribunals. And so we determined that it would be useful to at least set out the main criteria that ought to be at least considered when deciding whether to award costs or not, or what proportion of costs to award. So the first one, of course, is the outcome of the proceeding, being who won and who did not win, but also any part of it, so that tribunals will think about mixed success, for example, on motions or on jurisdiction, but not on merits or that kind of issue. The next criteria that we thought about was conduct of the parties. And in particular, again, we added the idea of being expeditious and cost effective, so that if somebody was successful in the case, but they really had not done the case in an expeditious manner, it might be a reason to reduce or withhold costs, and at least something for the tribunal to address when awarding costs. The next issue, of course, was the complexity of the issues, and obviously the more complex, the more you might expect that parties would spend more time or more pleadings or more discussion of the more complex issues that can arise. And the last one was the reasonableness of the costs. The idea there being that a tribunal might find that a party certainly deserved their costs, but if they were claiming hundreds of millions of costs, that might not be a reasonable indemnification for what they actually spent. So those seem to be, I think, pretty normal factors, but we thought it was worth at least listing those. There are two other new provisions on costs, and you'll find all of these in rules 50 to 52. But one of them was to give the tribunal the ability to make an interim decision on costs. And unlike many commercial arbitration rules, an interim award is not enforceable, or an interim order. There really isn't such a thing as an interim award at ICSID, but certainly there are interim decisions, and we wanted to encourage tribunals to feel free to give costs on an interim decision so that it could be definitely considered at the end of the day when considering the final costs award. And the other issue was the question of having a reasoned cost decision. That was something a lot of parties brought up. And obviously it's going to need some balance, because you don't want your arbitrators writing hundreds and hundreds of pages on costs, but many parties felt that it would be helpful to understand better the reasons for a costs award. So we wanted to bring those to your attention. And I think perhaps we're going to lead with Ms. O'Hara, and just what would your view be on these costs rules? And in particular, how do you think they will be applied? Do you think this will change the practice, or is it really more a listing and a reflection of the current kinds of criteria that tribunals use? And as well, what kind of information do you think parties requesting a costs order should provide to the tribunal to put them in a position to make that reasoned costs award?
Thank you, Meg, for explaining these new rules in detail. To your question, whether this new rule will change the practice or affect the practice, yet my humble view is yes and no. As you rightly mentioned, this reflects the current ICSID tribunal's practice in some way or another. But, ICSID tribunals practice evolve over years. When ICSID convention and ICSID arbitration rules were implemented, even the drafters originally thought that perhaps ICSID arbitration practice should be more consistent with the practice of state-to-state dispute where each party bears its own cost. So originally, ICSID tribunal took the approach more consistent with state-to-state dispute practice. So in reality, even if the Rule 52, proposed Rule 52 reflects the current practice, prevailing parties have to establish that this is the prevailing practice of the current ICSID arbitral tribunals. And now, once this Rule 52 will be implemented, prevailing parties simply refer to these rules, which is very helpful and save time and cost. Talking about the practice of the tribunal, now under new rules, tribunal has to issue reasoned cost award. Tribunal was awarded entitled to broad discretion in terms of allocation cost under ICSID convention. But because now new rule obligates the tribunal to issue reasoned cost award, now they cannot hide behind the discretion and perhaps has to refer to analyze each element enumerated in Rule 52, not only the outcome of the proceedings, but the conduct of the parties during the proceedings. One potential tricky point is item B of paragraph 1 of Rule 52 refers to the level of parties' compliance with these rules. And one of the interesting noteworthy rule is good faith obligation of the party to pursue the arbitration. So, the party will, of course, when they submit the cost, make the cost submission, they will refer to each of the elements enumerated in Rule 52 to try to persuade why they should receive cost award. Or even if the losing party may say that or even if the party have already got the sense that they may not prevail, they may argue that why cost award shouldn't be given to the other party. So the cost submission will be more in detail. And as Meg pointed out, cost award will refer to the discussions, findings on each of these elements enumerated in Rule 52. As Meg mentioned, it will add additional burden on the side of the tribunal, but tribunal can exploit this power to encourage parties to conduct the arbitration efficiently and effectively and comply with the obligation to run the proceedings in good faith. The second question Meg mentioned is what kind of information parties should submit. Well, it, I guess, depends on the tribunal. Tribunal oftentimes discourage parties to produce detailed evidence like invoice, but simply ask the parties to submit make the cost submission, which includes the perhaps number of hours party may spend and the total legal fees. But perhaps once this Rule 52 is implemented, parties are more eager to submit arguments and evidence to show why cost award should be of their favor, referring to each of the points. So it's remained to be seen whether tribunal will entertain those submissions, because at the end of the day, because ICSID convention remains in effect, tribunal has a wider discretion. We hope to see this reasoned decision will be published, and it will create a new guideline to the parties.
And that's very useful information, and certainly about the historic practice, which really was the state to state, everybody bear their own costs. I think that's very, very helpful.
Can I just add to what Yoshimi Ohara has just said, which I very much agree with, and in particular her emphasis on the overriding principle of good faith in the conduct of proceedings, which is, of course, like many overriding principles, extremely important but difficult to pin down, but necessary. So I would very much hope that the enumeration in Rule 52, useful though it is, would not be taken as an exhaustive statement of the factors that tribunals might think it right to bear in mind. I mean, the whole question of cost, it seems to me, has figured very, very large in the reform discussions, both in the ICSID rules and also in UNCITRAL. And of course, that's entirely understandable because it's a line item, isn't it? Both for claimants and perhaps particularly in this context, since they're the parties that also get to revise the rules on the part of respondent states. It's maybe unfortunate, if I may be forgiven for making this observation, that perhaps less attention has been given to the formulation of the law in relation to damages. Of course, that's a substantive question and not a procedural one, and therefore not amenable, not a subject for the ICSID rules. But in terms of quantum, if one gets to that point, of course, the figures for damages are much larger. And it's long been my view that the law on damages in investor-state arbitration would merit greater elaboration than the rather general indications that tribunals currently have to work with. But I'm not, in making that point, meaning to underplay the importance of costs, because the real concern here is that one engages in a battle of the most well-funded, not in a battle of the most meritorious claim. And again, when the Institute looked at this, they took the view that the ability of parties, whether or investors or states, to pursue or defend claims before a tribunal shouldn't be determined on the grounds of cost, which is a statement of the obvious, but it is a real concern. Mm-hmm. And that's particularly true, I think, in the case of small and medium enterprises on the claimant side and developing states, and particularly least developed states on the respondent side. And of course, the real expense here is not the expenses of the centre, or, dare I say it, of the tribunal, which are normally a rather modest element of the whole and which have been set by scale fees which have remained unchanged for a very long period. But the expenses of the legal costs of counsel. So I welcome the fact that Rule 52 will bring a bit more rigour into the cost determination process, and certainly the idea of the fact that the rules expressly direct tribunals' attention to making interim cost decisions, I think, is important. It's something I've regarded as being inherently within the power of tribunals in any event. Of course, one can't use it in every instance, but if the tribunal reaches the view that a particular procedural application is so unmeritorious that it ought not to have been brought and has wasted everybody's time and costs in the process, then in those circumstances, it can be appropriate to indicate at that point that whatever the outcome of the proceedings on the merits, the cost of that application must be borne by the the party that lost that particular application. One suggestion I would have, Meg, which you may want to think about going forward, it needn't be in the rules themselves, is Rule 51 simply makes provision for the parties to make submissions on costs. But as Yoshimi has rightly observed, there's no real standardized practice in the format as to how that should be presented. And obviously tribunals may be somewhat reluctant to receive just huge bundles of invoices. On the other hand, some standardization of the manner in which the information is presented could be very beneficial, because the other end of the spectrum, which is that you just get number of hours spent times hourly rate equals total, is very difficult for the tribunal to do anything reasoned with once it gets down to the question of your item D, the reasonableness of the cost claimed, beyond a mere comparison between the costs expended by claimant and costs expended by respondent, which is inevitably a rather blunt instrument. Now, again, I may be speaking from a common law originating perspective, with the common law's rather perhaps overly detailed provisions for taxation of costs, but some form of standardized process might be helpful here, because I know individual arbitrators have their own, sometimes have their own preferred format, but this is normally something that's left very much to the last minute. And of course, the amounts involved for costs can themselves be quite considerable.
Exactly. Now, that would be a good thing for guidance. I think that's very, very helpful. I wanted, in terms of decisions on cost, perhaps one issue that I did move by without stopping on, and I apologize, but if I could very quickly bring it up, because it's been a uniquely investor state type of rule, is the manifest lack of legal merit. And this was first put in the rules in 2006. And there we go, I apologize. And it was, I would say, sharpened up in this new set of rules, in that in particular, it made it clear that this manifest lack of legal merit rule could be applied not just to substance of the claim, but also to jurisdiction. And interestingly, there is a presumptive rule on costs where a party completely wins the manifest lack of legal merit motion. There is a presumption that they will get their reasonable costs unless the tribunal finds something out of the ordinary that justifies a different allocation. And that's based on the idea that this is not just sort of a legal argument, but that the tribunal will have made a finding that the case manifestly lacks legal merit, i.e., it never should have been brought. And certainly states are very concerned about the potential for frivolous claims. And this is a rule that allows a quick or summary decision at the beginning of the case on whether there is a manifest lack of legal merit. Now, it will be, I think, infrequent that you will get that kind of award because of the high standard, but certainly it has been used in practice. And so this Rule 41 sharpens the wording of the practice to date. And I think, Toby, you had some thoughts on this new manifest lack of legal merit provision?
Sure, thank you. I think it's probably important just to bear in mind the genesis of this, as Meg, as you've already explained it. There's always been a fear amongst states that they will be subject to frivolous, unwarranted claims, and that if somebody commences an arbitration, an ICSID arbitration, then there's nothing one can do if you think it's unmeritorious other than fight it. And that often then would, before 2006, that would engage the full procedure, which might then include exchanges of full memorials, full evidential hearing, and take a lot of time and costs. And of course, in the investor state field, the very fact of having a pending investor state arbitration against a party can have an adverse impact on that party. States' credit ratings can be undermined by the number of pending investor state claims against them. So it's in their interests to flush these out and get rid of them quickly if they can. And the Secretary General has limited screening ability, so that even if something looks on its face that it is unviable as a claim, there's obviously nothing the Secretary General can do, and the tribunal without a particular tool can't do anything other than possibly tighten up its procedure to get to a result as quickly as possible. So 2006 is where this came from, but that was quite a general rule that was established, and it was couched within the whole rule on preliminary objections. The great advantage now of this new rule is it sets out a separate regime for manifest lack of merit, and it clears up some of the issues that had been fought over in previous cases, such what this applies to. It's now clear it will be jurisdiction objections, as well as objections to the merits of a claim, as well as applying in post-award remedy proceedings. As Meg has mentioned, although this looks good on paper, in fact, it hasn't been used very often. The statistics that are available are, as of March of this year, there have been 40 proceedings in which an application has been made under the existing rule. That corresponds to only 5% of the arbitrations and post-award remedy proceedings registered in the same period. And actually, the results were not that significant, because there were only 7 awards which actually upheld the objections in full. There were 26 decisions dismissing the requests, 4 decisions partially upholding, some still pending. So what we get from these statistics is that this is not frequently used. When it is used, it doesn't frequently succeed. And that, I think, is because tribunals are reluctant to shut off cases, claims so early without actually having the benefit of a full articulation of a party's position. Just to close off this quickly, I think that this has advantages in some cases, but it also has disadvantages, because it actually can add to the complexity of the arbitration. It adds a further parallel proceeding, in a sense, where somebody tries their luck to strike out a claim early on. And if they don't succeed, actually costs may increase, time may increase, and indeed you may still come back to similar issues under a different heading, such as preliminary objections, which can happen as well as an application to strike out, in essence, for lack of merit. In many cases, the answer is not to add to the procedure by making such an application, but for the tribunal to tailor its proceedings in the main process to make sure that if something looks like it's unviable, the particular problems are heard early on. They are articulated as clearly as possible in the memorials, and maybe time limits are shortened accordingly. And that will be a function really of case management rather than the need for a specific provision such as this. But this will give some comfort to states, and we will see whether it's used any more than the current provision. Thank you.
Excellent. Another rule that started in 2006 is this whole trend towards transparency. And part of the amended rules was to continue increasing the transparency of the overall process. So when you look at rules 62 to 68, they encourage transparency, and in particular, encourage publication of awards and decisions and orders. And so there is a process here for ensuring that these hopefully get published. Parties still do have the right to refuse to give consent to publication of an award, in which case ICSID will do excerpts of the legal reasoning. But for orders and decisions, parties are asked to consent to this, potentially with redactions for validly confidential information. But there is a real encouragement to have publicly available the reasoning and decision-making in the case. We have also a rule that talks about hearings and making hearings public, which has been a definite trend in the last 10, 15 years. And so the hearings will be public unless either party objects to an open hearing. So a hearing can still be closed on the objection of a party, but is really encouraged to have them open. Obviously, you will go in camera where something truly confidential comes up, but the basic open hearing principle is encouraged here. There is also a new definition of confidential or protected information that should be helpful when you are redacting an order or decision, or addressing the question of whether a proceeding is going to be an open hearing and when it will go in camera. And then finally, the test for non-disputing or amicus participation is expanded, or the criteria that tribunals are to look at are slightly expanded. And finally, there's a new rule on allowing states to make what's known as a non-disputing treaty party submission. So in other words, the state that is not being sued, but was part of negotiating the treaty, will have the ability to make a submission on the interpretation of the treaty. So they can't basically get in and say the claimant is right or wrong, but they can address the proper interpretation of the treaty. And this is something we've been seeing increasingly in individual investment treaties, because they have an interest in the full evidentiary record of why a certain provision was included in a treaty and how it was worded. So there are a number of these provisions on transparency. And I wanted to ask if anybody had particular thoughts on the new transparency rules. I think Professor McLaughlin had some thoughts on that, and others may also have a number of thoughts on transparency, which is one of the big issues in investor-state arbitration.
Well, thank you, Meg. I think the transparency rules are amongst the most important and significant rules in the way in which they've developed in ICSID practice. And here, really, we need to reflect on the fact that ICSID has actually been the pathfinder here. And the impression that you would get from reading the formal treaties in this field is misleading. After all, the ICSID Convention, framed way back in 1965, talks about publication of awards only with consent. And in much more recent times, in the work of UNCITRAL with the Mauritius Convention and the UNCITRAL rules, we have this move to transparency. But in fact, in practice, at least in my experience, it's still the case that ICSID arbitrations are much more transparent than tends to be the case in many ad hoc arbitrations, whether conducted under UNCITRAL rules or otherwise. And in part, that's because of the encouragement that's been given in the earlier amendments of the rules, now continued in the present one, in relation to publication, and then the innovative rules in relation to participation of through amicus briefs of non-disputing parties. And of course, that's really important because really the debate about the public functions which investor-state arbitration performs is a debate which has been had and won decisively in favor of at least some form of transparency. Everybody accepts that that doesn't mean necessarily that every aspect of the procedure needs to remain open for all purposes, because there can be very significant confidentiality considerations which apply on both sides, both in terms of commercial confidentiality and also issues of state secrecy. But nevertheless, the legitimacy of a tribunal which is deciding on important issues about the exercise and potential misuse of public power must, in principle, be itself exposed to public scrutiny. And that is what the new rules seek to achieve through these amendments. Of course, what's in the convention is what's in the convention, and we can't change that. And you've gone probably as far as can be expected in relation to creating a presumption as to publication of awards unless a party objects. So from my perspective, the most significant procedural amendment is the addition in the rules of a specific provision in Rule 63 of publications of orders and decisions. This matters really rather a lot. At the moment, there is a very considerable body of important practice that is built up in tribunals in deciding procedural issues. It continues to amaze me how many important procedural issues arise which, however well the rules are drafted, still require tribunals to go back to essentially first principles. Some of that practice is in the public domain, but a lot of it is not. And for a stable jurisprudence to develop, of course, one needs to know what other tribunals are deciding. So Rule 63 creates, as I read it, an obligation to publish orders and decisions on the part issued by tribunals, and it leaves the parties with a right to object, not in general, but only in relation to apply for redactions on grounds of the confidentiality of particular elements of those decisions and orders. So that will bring into the public domain a much greater array of procedural decisions. Now, I have to say, in those cases which I've had where the parties have agreed in advance to publication of orders and decisions, the processes work very smoothly. On the other hand, in a case which is very determinedly fought by both sides, there can be often many procedural orders, sometimes on very sensitive questions. And it is quite foreseeable that the ability of the parties to object on grounds of confidentiality will create sort of a second bit of satellite litigation about which version of orders and decisions is to be released into the public domain. And we must bear in mind that whereas awards are produced often over several months and very anxiously considered and deliberated upon by tribunals, procedural orders often have to be produced very quickly in order to meet the timetable and the expectations of the parties and to maintain hearing dates and the like. And at a time when the tribunal and the parties are often under considerable pressure to prepare for the hearing. So it will be important that parties respect and don't abuse the ability to create collateral objections on confidentiality. On amicus curiae briefs or non-party participation, to my mind, the most significant additional element is the addition of the separate ability of treaty parties to intervene. That, I think, is potentially significant if it's utilised. A lot of the larger debates on the development of investment treaty law say, well, look, these are the instruments that the states have concluded. The states are entitled, as it were, to take control of the process and take an interest in how their treaties are being interpreted and to give guidance to tribunals. So the fact that this is an avenue that's expressly provided is a prompt to states themselves to take part in the process of interpreting, even if in the particular case, it's still for the tribunal ultimately to decide on the application of the treaty to the facts before it. One could say a lot more, but I don't want to crowd out others who will also have their own insights. Thank you.
In the interest of ending on time, I think maybe we'll just move on. We've got two more rules we'd like to highlight for you. The first is really the set of rules on mediation. These have been very much awaited by parties. And in fact, we have one or two cases where parties are using them by consent already. But what we have is a set of standalone mediation rules. They are basically available by consent of the parties. So they're quite easily accessible by the parties. And the consent can be either in the contract or treaty or instrument of consent, or parties can just ad hoc decide we would like to try mediation. And there are a number of special features in the mediation rules. And I think if Jerry can just move the slide forward, we have at least the beginning of the mediation rules. There we go, pardon me. And I wanted to see maybe, May, if you could start us off. What's your sense of these rules? Do you think states are actually going to be willing to enter into mediation proceedings? I know some feel that perhaps states might be a bit reluctant. Do you think it might cause delay to cases? And where do you think mediation proceedings can really have benefits to actually resolution of the dispute?
Thanks, Meg. I think it's wonderful to see ICSID responding to the user's desire for a less adversarial form of dispute resolution. I think it will be very popular, particularly amongst Asian states and corporates. And I'm quite optimistic that there will be a pivot from investor-state arbitration to investor-state mediation. So a couple of anecdotal evidence suggests, ICSID's review of BITs, for example, highlights how states have increasingly been incorporating forms of mediation into the BITs. There's also ICSID's very helpful statistics that show that the vast majority of investor-state disputes do not rather make it to arbitration, or at least do not make it through the entire arbitral process. So there's definitely an appetite and willingness to resolve disputes amicably, I think. And there's also a further need, I feel, between parties to keep control of the outcome. And what I mean by this is that they may not want a binary win-lose decision, but rather a tailored solution for their disputes, which is maybe a bit more creative, talking about the future, talking about continued relationship, etc. So I think the environment is ripe for these new rules to come in. As for your question on how to make reluctant states increase trust and involvement in mediation, I think the fact that ICSID has come up with these rules will be a game changer, because in the past, I think it's been quite a downside that the offer to mediate and then the person that puts together the mediation framework and guidelines is usually the investor. And the downside to this is, of course, not that the investor has to do the hard work, but rather psychologically, there's a lack of trust that will permeate a proposal because it comes from the investor. And that's, I feel, something that's always been a stumbling block. So the fact that ICSID's now offering an impartial and objective assistance to mediation through the rules, it's offering administrator support, facilities, a mediator appointing mechanism and authority. That's all extremely helpful, and I think will provide comfort and a level of much needed protection to the public officials participating in the mediation on behalf of the state, because the transparency and legitimacy that ICSID puts over this process should hopefully make corruption claims against these officials much more difficult to sustain. As for your concern about delay, I don't think, your question about delay rather, I don't think that's going to be a big issue. We're all big legal teams and other teams supporting the clients through this process, which can happen if the parties agree. In parallel, the arbitration and the mediation can happen in parallel, so it shouldn't cause much, if any, delay. There's no need for a stay in the arbitration proceedings. The mediation just needs to be timed very well. And in terms of timing of when to propose, it is not always a good time for mediation for one or both parties. So my experience is that it's important to raise it quite frequently. So before the notice of arbitration is a good time. Before the first meeting, it is also a good time. Before the hearing and after hearing are both equally useful times. Before the hearing, because you can persuade your clients that the hearing is a huge endeavor with a lot of costs and resources needed. So if anyone was to try mediation to avoid a hearing, that would be the good time to do it. After the hearing is also useful because your clients get to see the dispute, at least to a certain extent, through the tribunal's questions and what they've paid attention to and how your witnesses and the other side's witnesses have performed. So that gives an element of clarity about the legal case that they're up against. And so that may be a good time also to participate. And I would lastly conclude with the point that mediation needs to be a team effort, not just the lawyer, the legal team needs to participate, the clients need to take a very active role. And I would argue in due course that a lot of third parties who are neutral and respected by both sides can also play a more proactive role. So I know, for example, that the World Bank does have precedent of helping as a third party in disputes. We talked about it in an earlier prep session, but the Suez Canal dispute in the late 50s is such an example where, at the request of Egypt and the United Kingdom, the World Bank participated in negotiations to settle claims and which for expropriation and which were resolved amicably. So I think we should be pushing for this sort of third party, neutral and credible authority to come in to play more of an active role. I'll probably stop at that to give other people a chance to chip in.
Tremendous. Thank you very, very much. I wonder, just in terms of time, perhaps we'll just go to the last question. One of the things that has not been commented on a lot by those who've been involved in the rules has been the expanded access to the additional facility. And two things in particular. Number one is that neither party needs to come from an ICSID member state, which is not currently the case. So it will open up the additional facility rules to a number of parties that aren't currently eligible. And secondly, that a regional economic integration organization, and I think the example we all think of is the EU, but there are others, could be sued or could, as an investor, use the rules to commence as claimant an arbitration or a conciliation. So these are very new provisions, and I wanted to simply get the reaction of the panel on what might be the impact of these. I think Yoshimi and Eduardo, you were going to lead us off on this.
Sure, Meg, thank you for this introduction. Yes, it is exciting news because now all ISDS cases will be eligible for excellent ICSID administration, either under ICSID Convention or ICSID Additional Facility Rules. From parties' perspective, well, I have to confess that I haven't really looked into additional facility rules in the past. I've only seen one, a contract between state and party investors, which adopted this additional facility rules in the past. But it is exciting in a sense that this additional facility rules, I would say, is one of the most advanced arbitration rules nowadays, because as we have discussed, this additional facility rules have also implemented amendment to introduce more prescriptive process, having tighter timeline, and also obligates tribunal to be more actively engaged in proceedings, which we do not have in most of the institutional or UNCITRAL arbitration rules at this moment. So we hope this will set the new standard for arbitration practice.
Just agreeing on what Yoshimi has said, just a couple of additional comments. Number one, this will make a difference in the sense that even though most of the institutional rules are trying to adapt to ICDS cases, the experience and the expertise of ICSID is well ahead of other institutions. So that's the first thing. And the second thing is that these rules were envisioned from day one for these type of disputes, even though the use was relatively limited. For example, in the old NAFTA cases before Mexico and Canada ratified the ICSID Convention, now is going to be an open forum, an open alternative for a number of investors and states, with number one, as I said, rules designed specially for this type of dispute, which is not the case of the rules of other institutions. And number two, with the expertise of ICSID in investment cases, which I think is unique.
Thank you very, very much. I think in the interest of time, I'd simply like to thank our panel so much for an incredible discussion, and to thank the attendees and the organizers so much for this opportunity. And I will pass the microphone back for final comments from the JIDRC and the Department of Justice. Thank you.
Thank you, Meg. And I'm mindful of the time, but with your kind understanding, I would like to pass the floor to Fumi to convey his closing remarks. Fumihiko Yanaka is director of the international team of the Litigation Bureau of the Ministry of Justice, and he has been leading the team since this April. Fumi, you have the floor.
Thank you, Takashi, for your kind introduction. On behalf of co-organizers, I have the pleasure to make closing remarks at the end of this session. First of all, I'd like to express my sincere gratitude to Ms. Meg Kinnear, Senior General of Secretary General of ICSID, for co-organizing and moderating this session. As you know, we had intended to invite Ms. Kinnear to Tokyo until last week. Unfortunately, due to the new phase of COVID-19, we are not able to welcome her in Tokyo. However, digitalization, which is one of the main themes of this session, made it possible for us to hold this session. And I strongly believe Ms. Kinnear's wonderful moderation made this session so successful. I would also like to express my sincere appreciation to all the distinguished speakers. It's a great honor for us to invite such speakers who have abundant experience and expertise based on their various backgrounds. The diversity of speakers has deepened the discussion today. And finally, I would like to thank Ms. Geraldine Fisher, who are here, for her tremendous contribution to the preparation for this session. As Ms. Kinnear mentioned yesterday and today, Japan is one of the first contracting states to the ICSID Convention. The bond between Japan and the ICSID is long and strong. I'm convinced that the strong relationship between Japan and the ICSID enable us to co-organize on today's event. The main theme of this event was ICSID Rules Amendment and the investor-state disputes in the digital era. Japan has been actively participating in the ongoing ICSID Rule Amendment project. As Mr. Tsushima, the State Minister of Justice, mentioned yesterday in his opening remarks, the Ministry of Justice has engaged in the amendment project by proposing some concrete revisions to strengthen the draft rules, and is very pleased to contribute to the amendment process. Today's discussion have addressed the important topics of amendment project, including a provision of general duties on the tribunal and the parties, increased use of electronic filing, case management conferences, third-party funding, security for cost, a proposed ICSID mediation rules, and expand access to the additional facilities. Today's discussion have covered some topics concerning our proposal, and I have listened to them with great interest. As Ms. Kinnear explained today, the sixth working paper was released last month, and I recognize that the ICSID is scheduled to adopt the amendment rules in 2022. Thus, it's very timely to discuss the major issues of ongoing amendment project to move them forward through this session. The amendment rules, when adopted, will modernize the rules, make the procedure increasingly time and cost effective, and enhance the transparency of proceedings. I'm convinced that the proposed rule will form the strong basis for overcoming challenges in the new era. I hope this session can contribute to the process of amendment project and promote the successful adoption of new rules. The Japanese Ministry of Justice is determined to continue to support ICSID and the Rules Amendment project. And finally, once again, thank you to all participants and to everyone involved in planning and holding this event. We are grateful for your valuable contribution and attendance. Thank you very much.
Thanks to you from me. And allow me to offer a final big virtual round of applause to Meg and all the distinguished panelists. Thank you to all the attendees for their participation as well. We will resume the forum at 4:30 p.m. Japan Standard Time, which is 7:30 a.m. Greenwich Mean Time, for starting with session 3. Thank you once again.